Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Video number 1411. This time we are going to discuss case law on insurance. That is, we cover it under the law of torts. So you may be knowing there are two types of insurances. One is comprehensive and second one is at least third party insurance. Of course, here this case is relating to employees or workers compensation act. So if any worker dies, you can claim under section 166 of the ME Act or the Workmen Compensation Act. Right. So here the Supreme matter has come to the Supreme Court. Supreme Court has given a judgment that insurer cannot deny the coverage, saying that the deceased was a helper and not a cleaner. So the insurance company cannot deny their responsibility. So they should not deny to indemnify the deceased person, saying that he is only a helper and he is not a cleaner. What is the differentiation? Actually, nobody knows. Even a helper works like the so-called cleaner also. They are not clearly stretched differences, clearly demarcated differences between these jobs. They are all menial jobs, very low cadre jobs. So while deciding the case of Messrs. MANILAL VAISHNOI, they are borewell drillers versus National Insurance Company Limited in Civil Appeal number 291 by 2022. Honorable Supreme Court, 2 judges bench, Hemant Gupta and V. Ram Subramaniam. So they held that the insurance company cannot deny to give insurance to the helper, saying that he is not a cleaner. Right? So this is what is observed. Please remember, the Supreme Court held that denying the compensation or the insurance coverage under the Employees Compensation Act or Workmen Compensation Act 1923 for the reason that the deceased was employed as a helper and not as a cleaner is wholly unjustified. It is not correct. Yes. Because they have taken into consideration the absence of any clear-cut demarcation of duties, and the terms helper and cleaner, they are used quite often interchangeably. A helper is called a cleaner is called a helper. So there is no specific difference between these two appointments or these two posts. Right. So but here actually the trial court has correctly given, but when the matter has come to the appellate court or the high court has accepted or has believed the make-believe argument of the insurance company. Now Supreme Court has clarified in this connection. Right. So let us go into the details of the case. The deceased, Mr. Tej Singh, he was appointed by that is appellant MANILAL VAISHNOI company as a helper in their borewell machine. Right. So he died in the course of employment on the borewell vehicle. Then a petition was filed before the Employees Commissioner, that is Workmen Compensation Act. A petition was filed for grant of compensation. The Commissioner granted compensation of 3.27 lakhs. Roughly he has calculated. It came about 3.27 lakhs. This award was given in 2005. So normally insurance company, they will not keep quiet. They will pay 50% of the amount or 1/4 of the amount and go for appeal. Same thing they have done. They have gone for the appeal. So they have filed appeal under section 30 of the employees, that is our workman. Normally we call it as Workman Compensation Act, but in this particular case it was given as Employees Corporation Act. Right. Here the High Court was made believe by the insurance company that the deceased was a helper and he is not covered on the policy because the policy covered only cleaner. So therefore, already the insurance company paid the amount, 2015, already they have paid the amount. Therefore, High Court has given the liberty to collect the so-called insured amount which was paid to the deceased to be received from the appellant, that is MANILAL VAISHNOI. So this is the order of the High Court. So agreed by the order of the High Court, this MANILAL VAISHNOI, they approached the Honorable Supreme Court of India. So yeah, the Supreme Court noted that the appellant MANILAL VAISHNOI, he sought indemnification of 5 other employees who are engaged in loading or unloading the activities. So he has paid the extra premium also, not only for the driver but also 5 other persons. Now the question is whether the helper is included in those 5 persons or not. Whether he is included or not, if he is one of those 5 persons, definitely the insurance company has to indemnify. That is what is stated by the Supreme Court. Why? Because, please remember, the insurance company has to cross-examine the witnesses, or they have to elicit some more evidence to say that the client, the deceased, to say that the deceased was not engaged in loading and unloading activities. When he is involved in loading and unloading, definitely he is a cleaner, and whether he is a cleaner or a helper, when he is engaged in loading unloading activities, definitely the compensation or the indemnification has to be paid to him, and that is what is observed by the Supreme Court very clearly. So nowadays, even in my previous video also, High Court is somewhat being guided by the so-called make-believe arguments of the petitioners. Anyway, Supreme Court has to come on. Justice Ram Nageshwar also came heavily on the High Court of Allahabad. Now once again, the Supreme Court has to come down heavily on the High Court. High Court has not appreciated the matter correctly. They have not elicited the matter correctly. Whatever it is, of course, to err is human, we cannot say anything. But Supreme Court has given this notable judgment saying that there is no difference between a cleaner and a helper, and if the insurance is there, definitely it has to be paid. Very good judgment, particularly for the MV Act practitioners, and please read the judgment and enrich your legal knowledge. Thank you very much.